Hello and welcome to Shoosmiths Monthly Podcast. This month we're talking Part 36. Your speakers are myself, Matthew Cole, Simon McArdle.
Hello, thank you very much for having me.
And Erica Simpson.
Hello.
Now, today we're going to talk about ensuring compliance when making a Part 36 offer, because to be frank, the three of us could talk about Part 36 till the cows came home.
Yeah, if we take it outside the bounds of just qualifying, then we'll be here all day.
I mean, it's mind-blowing the level of detail that we could go into.
Many a winter evening has been whiled away in front of a fire discussing Part 36 and watching X Factor.
Now, what we have found recently is that parties need to be extremely careful when making Part 36 offers. But we thought that we would do a little bit of a role play of a client getting some advice on a Part 36 offer in an attempt to, get that information across to you in an easily bite-sized manner. Right.
You're getting into character now.
Getting into character, yeah. Sorry, I just need to take a little moment there.
Am I me in this? I'm still me.
You're still you.
Right.
Erica,
And I'm still me.
Yeah, you're playing you. It's only me. I'm going to play Dave Smith, a.k.a. client. Right. Hi, guys.
Hi, Dave.
Hi, Dave.
Hi. I'd like to make one of these Part 36 offers if I can. And I've been thinking about it. Should I just pick up the phone to the other side and make it?
Oh, unfortunately not. The civil procedure rules are quite clear that a Part 36 offer must be in writing, and even that it must state on its face that the offer intends to have the consequences of Part 36. And so, as such, our advice to clients is always that a Part 36 offer is in writing and literally must use those words.
Ah, that's right. I remember now, because you guys very helpfully sent me that briefing update on Part 36 last month.
That's right.
And I remember there was that point that came out of the case of Carillion JM Limited and Fee Group Limited 2011 EWHC 1581.
I'm so pleased to see that you've memorised the exact case reference.
Oh, well, it really knocks me for six.
It's a good skill in dinner parties, I'm sure.
Indeed. And that talked about consequences, didn't it?
That's right, yeah. In that case, the court decided that where a party made an offer which was intended to have the consequences of a Part 36 offer, and there was ambiguity as regards the wording of it, the court actually said that that offer should be construed so as to give effect to the party's intentions. However, that wasn't the end of the story, because conversely, in the case of Thulis and Group Armour, the court didn't agree with that approach. In that case, an offer to settle proceedings stated that the offer was made pursuant to Part 36 of the CPR and remains open for acceptance for a period of 21 days from your receipt of this offer letter. Thereafter, it can only be accepted if we agree the liability for costs or the court gives permission. After reviewing the other authorities, the court held that the wording used in that offer meant that the offer didn't actually comply with Part 36 because it failed to state that it intended to have the consequences of Part 36. Quite a harsh decision, but emphasising that unless the party ensures its offer complies with Part 36, there is a real risk that the court will decide the offer is invalid.
So in essence, Dave, you really cannot rely upon the court helping you out.
No, I don't want to be taking those sort of risks in, in them saying it's not right. I think if we do it, let's get it right at the outset. Now, there's a point about the time limit, isn't there? I remember that when our firm did one previously, we set a certain time limit on the offer. And we can still do that, can't we?
No, we can't do that. The courts have been very clear in respect of the time limits as well. The time limit that we are required to give for a Part 36 offer is not less than 21 days. But if you were to, say, build in an automatic withdrawal provision into your letter, then the courts may well find that your letter is defective for the purposes of Part 36. So it essentially has to be an open-ended letter.
Okay. So, but if I make my offer and the 21 days pass, what do I do then?
Well, you don't have to do anything. As an open-ended letter, you can just allow it to stand open for the foreseeable future and all the way up until trial. It is possible to withdraw it if you want to, but there are consequences in relation to that.
And there's another benefit of keeping the offer in writing only, because you can keep a record of the fact that it's been made and when it was made. It's important to remember what offers have been made and when, because if the merits of your case changes, you might decide that you don't want to make that offer anymore, but it needs to be expressly withdrawn. And even making a second offer doesn't extinguish the first, so it's important to make a note of and remember what offers have been made.
Okay, I'll have to make a diary note for that then. Now, obviously, I've got a lot of issues in this case, and there's a lot of different points that are brought up. Now, will my offer cover everything?
Well, we'd need to make that clear. You'd need to make that clear on the face of the letter as to whether it relates to the whole of the claim or part of it or to one particular issue. You'd also need to clarify whether it was intended to take into consideration any counterclaim that might be in play at the time that you send the letter.
Okay. Well, thanks, guys. That's been really helpful. And just to clarify, so I now know my offer needs to be in writing. Unfortunately, I can't just give them a bell and say, here's some money, go away.
Spot
Yes.
on.
It's got to state that the offer intends to have the consequences of Part 36.
Yep.
Specify a period of not less than 21 days for acceptance.
That's right, doing well.
3 for 3. I've got to say whether it's going to be to all of the claim or just to some of the issues that we've picked up,
Yep.
and also whether I want to take into account their counterclaim.
Brilliant. Yes. we've
See,
got
that's
there.
that photographic memory's coming back into play once again. Okay, thanks, guys.
No problem.
End of role play.
Great, that was good. So you're Matt again.
I'm back to being Matt. You're still Simon and you're still Erica.
Great.
Fine. Okay, well then hopefully that is just a helpful little pointer there, setting out the various needs that you need to go through to ensure compliance when making an offer. We have seen, the detail that courts are now looking at it, and these recent cases that we cited earlier have highlighted the potential pitfalls that can derail any offer.
And I think it's worth bearing in mind that part of the reason for this stringent approach to Part 36 is how powerful Part 36 can be when it comes to making costs awards down the line. As I think we mentioned earlier on, there are separate briefing notes available online in respect of the consequences of Part 36. But for the time being, I think it's probably worth bearing in mind the advice that was given to young Spider-Man, that with great power comes great responsibility. And I think that applies here to Part 36 just as much as it applies to superhuman spider-like strength.
Yeah. It's not often that you see parallels drawn between Part 36 and a Marvel comic book, but there is a very
great opportunity
to do so. And a couple of buzzwords that we use here at Shoosmiths Towers when thinking about Part 36 offers are always compliance and clarity. Now, we've talked today about making an offer from the position of a claimant. What we have to think about is also, if we're a defendant, we should be really key on Part 36 as well. Is it compliant? Is it not? Is there a way that we can try and get back on it? In any doubt, what you should look to try and do is seek specialist legal advice. If you do want some more information, please do read the article on Shoosmiths' website entitled Walking the Part 36 Tightrope When Making an Offer. Erica, have you ever walked a tightrope?
No.
No.
I missed out.
No. Something maybe to do in later life. And please don't forget to record your time for CPD purposes, and do not hesitate to contact either myself, Simon or Erica if you want to discuss anything in more detail. Many thanks, and look out for the next Shoosmiths podcast.